Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 285 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps clients manage risk across 4 key risk areas. These risk areas include sales and sales channels, including distributors, resellers, and partners, suppliers, customers, and human capital, which consists of employees and contractors. You can check out more information on the Red Flag Group at www.redflaggroup.com. As listeners of this podcast know, I am the compliance ambassador for the Red Flag Group, and I'm pleased to announce another upcoming webinar on supply chain risk management. This will be our third in a series, and will be on using technology and analysis to manage your supply chain risk. It will be on Thursday, October 20th at 10 a.m. Central, 8 a.m. Pacific Time. You can register and get more information at insights.redflaggroup.com. In this episode, I visit with Francine McKenna. Francine is well known to the blogosphere world for her blog, In Ray the Auditors, or Ray the Auditors. And she has now moved over to MarketWatch, which is a Wall Street Journal publication. And in this podcast, I talked to her about the Taylor Bean-PwC case. Francine goes into great detail to explain to us the case and how it was so dangerous for the big 3 auditing firms. It's really a fascinating interview. Francine is just a wealth of knowledge of all things auditing and in the auditing world, and now with her position at MarketWatch, we talk about some of the trends she's seeing. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance Report. Today, I'm extremely pleased to have back with me my good friend and colleague, Francine McKenna. Francine is now with the Wall Street Journal at the MarketWatch Group and taking a look at auditors, the DC scene, the SEC, and lots of different things that, and she's got a platform now that she can really talk to us on some of these issues. So Francine, welcome.
Hi, how are you?
Good. So I have been wanting to visit with you about the Taylor Bean-PwC lawsuit for some time. I think most folks know it's settled this summer, but I thought maybe now that there's some resolution around it, if I could maybe get some of your thoughts about it. From what I could tell, it was one of the rare suits that actually got to trial. Lots of suits are filed, but they're usually resolved, certainly short of trial. But here we had the bankruptcy trustee bringing suit against PwC for failing to spot a multi-billion-dollar fraud, which led to the demise of Taylor Bean & Whitaker Mortgage Company.
Yeah, it's actually even more unique than that. As you know, as you mentioned, the Big 4 auditors rarely ever go to trial on anything massive. It's not that they don't go to trial at all. Sometimes there's small employment kinds of cases, or consumer in the ordinary course of business kind of, vendor relationships, etc., but not break the firm kind of auditor liability cases. 99.999% of the time in the last 20-30 years, those get settled. And this was one of those rare cases where it got this far and actually ended up in a live trial down in Florida. But the case is a little bit more complicated than that, in that it was really a dual fraud, a collusion between executives at Taylor Bean & Whitaker, the CEO, Mr. Farkas, and two more people at Colonial Bank, which was a very large regional bank in Alabama. And those 2 banks had people on both sides that colluded in a fraud that basically broke both of them, put both banks into bankruptcy after a raid by the FBI on both banks. And so the trustee from Taylor Bean was actually suing PwC as auditor of Colonial. Taylor Bean's auditor, Deloitte, had been sued previously, and they settled a couple of years ago. And the case against PwC was unique from that perspective, in that it's usually hard to get the auditor of a company that fails or has some massive fraud to trial, let alone the auditor of the organization that the fraud colluded with. And so it was really a test of wits between the plaintiffs and the defense attorneys.
One of the things, I guess a couple of things struck me, Francine. First of all, in my former world of being a partner in a law firm, we had malpractice insurance that would cover this sort of thing. So I would have to assume that PwC had an equivalent type of auditor liability, or the equivalent of malpractice insurance, so that there would be some insurance funds available with some input from the insurer about the trial strategy. Not really.
They do not.
They do not.
That is one of the unique characteristics of the large global public accounting firms. In particular, here in the U.S., there is no insurance company other than their own captive self-insured vehicle. They all four have a self-insured vehicle in Bermuda, and they used to actually be jointly insured together in a captive insurance company, but they split that up a few years back. And so there really is not the traditional insurance coverage available to the rest of the firms down the line. So the next tier firms, the BDOs, the RSM, Gladries, they do have some level of coverage. And then, of course, the thousands of smaller firms also have auditor liability coverage. But the big four are self-insured. And so there is sort of a self-interest on the part of each of the four to make sure that none of them end up in this situation, because what's bad for one is really bad for all in terms of developing a case strategy or an approach by a particular plaintiff's firm or a group of plaintiffs' attorneys. Once you start making a wedge into the firms, once you start having some successful strategies, then they can be used effectively against all four, and all four are then vulnerable.
So thanks. Now I understand that much better. What do you have any thoughts on why PwC let this matter go, actually starting trial and certainly through opening statements?
Well, again, in addition to the fact that we haven't seen a break-the-firm case like this for 20, 30 years, not since Arthur Andersen was in this position after Enron, and that firm was already pretty much gone. The cases like WorldCom and Baptist Foundation that Arthur Andersen faced, the firm was already gone. So even though those went to trial for a brief period, I think one of them was a couple of days, one of them was barely a week before they settled, there has not been a big four firm that's gone to trial that's a viable firm that has had to fight basically a case that could have put them out of business. The claim in the Taylor Bean case was $5.5 billion. But beyond that, and the fact that the case was against PwC, not even as the auditor of Taylor Bean, but as the auditor of the bank that it colluded with, Colonial, PwC, I wrote back on August 12th, is actually facing 3 trials. So the Taylor Bean case was the first one to come up, but now PwC is facing the trial for the Colonial Bank case itself. That's scheduled to go to trial in early January. And then another case related to MF Global, which was a very contentious bankruptcy that occurred, again, based on more than $1 billion going missing, a very risky strategy by the former governor and senator from New Jersey, John Corzine, as CEO. Are you still there?
Still here.
Oh, And that case is going to trial over an investor claim of incorrect accounting advice to the MF Global organization. So PwC was not just facing one break the firm trial, but two more that are still pending that in combination over a very short period of time could certainly subject it to what some analysts that I talked to consider to be a tipping point. In other words, the amount of money that the U.S. firm itself could just not pay without having liquidity issues.
When you gave us the recitation of the facts, though that was certainly unique. Typically, you don't see both parties to a transaction colluding in fraud, although you do see that occasionally. Does that bring up even greater difficulties for an auditor?
Well, I think that the defense in the case that Taylor Bean brought against PwC's defense was that was one that is used in general almost any time they're sued for any of the big firms are sued for auditor malpractice, and that is that the audit is not designed to detect fraud. The other defense that they used was that the auditor does not owe any duty to anybody other than the client itself, so the client to the audit report. In this case, the plaintiffs were trying to stretch that a little bit and say, no, there was a public duty to stakeholders in general, in particular Taylor Bean, because it was a party to transactions with Colonial and depended on audited financial statements in order for those transactions to be possible at all. The uniqueness of the trial was that almost all of the testimony, they only got through basically the first 3 weeks. The plaintiff's case, testimony by witnesses and others that were deposed before the trial, basically was just that, just the plaintiff's case. But it was all having to do with what happened at Colonial. So when we look at what's coming in January for the case against PwC for its audit of Colonial itself, the public has now seen the case, and arguments that were in the past presented in private and then perhaps sealed up again when a case was settled before trial. Depositions and other kinds of rationale and motions and different kinds of things that were done as part of the strategy, basically then got buried again. And the public never really got to hear the auditor's fundamental defense, which is the audit is not designed to detect fraud. And that did not play very well from a public perception perspective. Media reports of some of the information that was conveyed in the trial just did not play very well. And so it'll be interesting to see whether PwC thinks they can get better at it when they present basically the same evidence in the same case for Colonial.
Let me go back to your recitation of the plaintiff's legal theory, and I thought that was interesting. You said that they were trying to stretch it out to create a duty to other stakeholders. It seems to me that would, if that legal theory was upheld by a trial court or a court of appeals, that could significantly expand the potential liability to any auditor.
Absolutely, absolutely. And there were several pretrial motions where the defense basically fought against that premise itself, and it was allowed to go forward. And during the case that the plaintiff made, it seemed that they were making good headway in making the case that the auditors, PwC, knew that their audit for Colonial would be used by Taylor, Bean, and Whitaker and its executives, and some of the government entities, the government-sponsored entities like Ginnie Mae and Fannie Mae, who actually bought the mortgages from Taylor Bean by way of Colonial.
So I guess we're just going to have to wait now and see for the two additional trials you talk about, or certainly the Colonial trial for PwC, and see if that one actually gets into the courtroom as well for the trial testimony.
We'll see. It's going to be interesting because the plaintiff in that case, in the Colonial case, is actually the FDIC. And the FDIC has traditionally been anxious to settle. I've talked to many attorneys who've worked with the FDIC on cases on both sides, and they were a little surprised that the FDIC has taken this one this far. But I guess between the two banks, Taylor, Bean, and Colonial, it was just such a massive collusive fraud, and it caused an enormous amount of harm on both sides. And it was a crisis era case that really points up, these basic principles, and it was a good opportunity to get them out in the public.
Francine, I'd like to turn now to another matter, which it's not really a case. I suppose we could call it an enforcement action, but it's tangential to that. And that's the anonymous Monsanto whistleblower who has been very public in his criticisms of the resolution by the SEC with Monsanto. One, that the company did not, or the SEC did not investigate or charge the company, any higher ups with the company. But the point I wanted to focus on was he also asked the SEC to specifically investigate Deloitte around this matter. And for those not familiar with this case, Deloitte had audited Monsanto. Monsanto had taken certain rebates and moved them into another sales year. This was approved in the audit, and that's what the SEC sanctioned Monsanto for. And here, I guess I'm going to kind of have to rely on your expertise on what's the role of an auditor if a question is raised. I would certainly think that an auditor could defend their audit. And if, as with many questions in accounting, it seems to me that it's a question of interpretation, and perhaps it could go one way or perhaps another, but if a reasonable or reasoned argument is made, why can't an auditor defend that conclusion?
Well, again, this is an interesting case because it's pushing the limits of things like how whistleblowers are going to act in the future. The whistleblower protections allow for people to make these claims anonymously. The FCC awarded this whistleblower the second largest award that it's ever awarded. This person, you would think, would go away happy. Content to just sort of, spend their money and not cause any more trouble. But instead, this person feels very strongly about the fact that the resolution just doesn't satisfy him or her in terms of the company and also the auditor. And I talked to that person's attorney today. The person has empowered his or her attorney to talk about the case. They gave an interview to Gretchen Morgensen in the New York Times to talk a little bit more about these issues without revealing this person's identity, but with talking about, again, who was the company that was behind this massive whistleblower award by the SEC. Again, a piece of information that usually the SEC doesn't provide. We have a hard time sort of matching up, action and reaction when there's so much anonymity. And this particular person has decided that he wanted to, pull the curtain back a little bit farther. I'm using I'm saying he, but I don't know if it's a female or a male. I'm just using that for convenience. But the thing is the case really goes back to there was some issues around accounting at Monsanto, and Monsanto, after learning that the SEC was going to investigate, determined that they needed to make a restatement. And a restatement, again, is where a company realizes that there's been errors of such significance that they need to actually go back and revise the prior period financial statements and make those formal disclosures to shareholders and the public via the SEC. And so they made a restatement, but what this attorney says on behalf of his client is that the restatement itself was self-serving. And it was self-serving because the company, when they found out about the SEC investigation, didn't actually hire an outside investigative firm. They didn't hire another forensic accounting firm. that it was the auditor, Deloitte, who supported the company in figuring out, well, if the SEC thinks that there's something wrong here, here's how we're going to fix it. And they're saying that basically they fixed it in an incorrect and self-serving way so that the company could still meet its sales growth goals. And they would like the SEC to go back and relook at how the restatement was done, and potentially for the SEC to look at whatever kind of complicity the auditor might have had in both helping the company not dwell on what errors were made and still meet its sales goals by the way it revised the numbers, and how the auditor then avoided any further scrutiny or potentially being named as a defendant in any kind of lawsuit, et cetera, related to the restatement.
So this one, we've had a couple of whistleblower issues that have, I wouldn't say have gone sideways, but have not really gone on the straight line that most whistleblowers who receive awards do, this one being one, the anonymous Monsanto whistleblower. And we also had a disclosed whistleblower in a Deutsche Bank SEC enforcement action who very publicly declined his award because he was not satisfied that the SEC had thoroughly enough enforced the matter against Deutsche Bank, and wrote an op-ed piece in the Financial Times articulating his reasons. So the whistleblower provisions to Dodd-Frank, the whistleblower office in the Securities and Exchange Commission have really brought forward a whole new level of information to the SEC. And I can only think that that's going to continue to be a growth industry and bring up lots more issues that you and I are probably going to get to visit on in the future.
I totally agree. I'm going to speak tomorrow at National Association of Corporate Directors, their conference here in Washington, D.C., on these kinds of issues around communication of problems from the board perspective. And I think that the whistleblower programs in particular have really changed the landscape. It used to be that journalists and others would get tips from people, and most of it was things that you would not necessarily think were legitimate, because people really, that was the only sort of outlet, and most people sort of kept things under the woodwork and were afraid of losing their job and retaliation and all kinds of other issues. But instead, the whistleblower programs and social media to support it from that perspective have really opened up sort of the lid on these kinds of issues, and people, I think, feel more empowered talking about them. They feel more empowered publicizing their perspective, even when they're still enjoying a level of anonymity. They have a platform and they have a vehicle to get this information out, and I think the companies probably didn't anticipate that aspect of it. They were more concerned about the information seeing the light of day, period, let alone that once they thought they had put it to bed, that it would continue and that you'd have people who just didn't take the money and walk away happy.
It really emphasizes to me the point of reputational risk is becoming exponentially greater, particularly in this era, as you suggest, of greater social media knowledge and use by a wide variety of stakeholders. So with the recent resignation of the gentleman who started the SEC whistleblower office, Sean McKesney, and moving into the private sector specifically to bring whistleblower cases, I can only think that this is going to be a conduit of information directly to the SEC, which could be some meritorious, a lot of meritorious claims moving forward, particularly if companies do not take these internal whistleblowers complaints seriously when they're first given to companies and they allow them to go to the SEC.
And I think it also points up the issue that a lot of companies thought. They thought that the money was going to motivate people to fabricate or exaggerate or even lie about issues within companies. And instead, what we're seeing with some of these recent cases like the Deutsche Bank whistleblower and this Monsanto whistleblower, that it's not totally about the money. They still want to see the right thing done, and they're going to continue to pursue the cases and perhaps stand up and be counted in order to make sure that pressure is brought to bear so that the right thing ends up getting done eventually.
You know, that specific point really struck me about the Gretchen Morgensen article, and I've got that in front of me, and she quoted the anonymous whistleblower for the following: management not being held accountable, that still bothers me. I went into this to get that fixed, and that didn't get fixed. And it goes exactly to your point where I think people are motivated by wanting their companies to do the right thing, and they're becoming increasingly frustrated, and they're moving to other avenues to publicize these. Francine, unfortunately, we're near the end of our time, but I probably could have done this for several hours with you. I always greatly enjoy our conversations, but I was wondering if anyone wanted to follow up with you or perhaps send you a whistleblower tip. Could they email you, and if so, how would they do it?
Absolutely. Call or write anytime at fmckenna@marketwatch.com.
Francine, thanks a lot, and I look forward to continuing the conversation.
Me too, next time.